Alright people, so welcome to Jumbo IS and welcome to our lecture series on current affairs. Now today is the turn for Indian polity related current affairs. So all the important news items with respect to the subject of Indian polity from the past 1 week shall be covered in today's lecture. Now as you all know that we cover current affairs subject wise and we cover 1 week's current affairs related to one particular subject in one lecture. And this lecture is less than 30 minutes. So you can easily make it a part of your daily routine and you have to do that. 30 minutes of watching the lecture and 15 minutes of quick revision from the notes. The notes are provided by us on our Telegram channel and the link to our Telegram channel is provided in the comment section below. But make this lecture series a part of your daily routine because if you'll do so till your examination, well, you'll be really amazed how beneficial this is. You'll have current affairs in your control and you'll be ahead of 99% of your competitors in this exam. So make sure you make it a part of your daily routine. All right then, enough of the introduction. Let's straight away dive into today's lecture. So let's begin. So current affairs, Indian polity, July part 3. And here are the topics that we are going to cover today. Okay. So number one topic is new law for Vande Mataram. So basically the government is bringing in a new law which will bring Vande Mataram equivalent to national anthem, that is Jana Gana Mana. So what is this controversy or what is this issue all about? Let's talk about this. And topic number 2 is related to, are protests legal in India? Of course they are. But what is the legality of protesting in India? Okay. What is the legality? That is very important for you to understand given this recent controversy in Delhi, as far as Jantar Mantar protests are concerned. Topic number 3 is two-child rule for Panchayat elections. Many states have made it mandatory that you need to have a maximum of 2 childs to contest Panchayat elections. If you have more than 2 children, you are disqualified from contesting Panchayat elections. Now, the Supreme Court has said that we need to review this, okay, because it can violate certain fundamental rights. So we'll talk about this issue. And in the end, we'll talk about, can courts stop a Central Board of Film Certification certified film? Because Odisha High Court recently banned a particular film related to Lord Jagannath. So, and it was certified by Central Board of Film Certification. So CBFC, can court stop CBFC certified films? We have to look into the legality of this issue because it involves fundamental rights, especially fundamental right to free speech and expression. Okay, so these are the 4 news items that we shall zero in our attention on. So let's start discussing them one by one, starting with topic number 1, and that is new law for Vande Mataram. Now listen to me very carefully, okay? You know, Vande Mataram is basically national song of India and Jana Gana Mana is national anthem. Now, when India got independence within the Constituent Assembly, the first president of India, Dr. Rajendra Prasad, he made this claim, he made this speech that Jana Gana Mana and Vande Mataram would be treated equally. Okay, that was the speech made by him. But if you take a look at the law, the legal aspect, well, Jana Gana Mana has a higher status than national song Vande Mataram. How? We have a law called Prevention to Insults to National Honor. You know, whenever Vande Mataram, Jana Gana Mana, the national anthem is playing, there is a proper code of behavior that you have to follow. You cannot insult national anthem. You have to stand when it is being played. All these things, all these rules and regulations are there. Well, these rules and regulations are protected by that law. Similar protection is not awarded to national song Vande Mataram. So what the government is doing, well, they are bringing an amendment bill to bring Vande Mataram at par with Jana Gana Mana. You understand? Now, similar rules, similar code of conduct, code of behavior shall apply to national song. Make sense? So what is this issue all about? We need to take a look at this law, Prevention of Insults to National Honor Act. Plus, we also need to go back in history and understand the evolution of this national song. Okay, so we have to do that. So let's get all the information required for this topic. All right. So new law for Vande Mataram. So this was in the news. So government is introducing an amendment bill, Prevention of Insults to National Honor Amendment Bill in Rajya Sabha monsoon session. Okay. Now this law was enacted in 1971 and it gave Jana Gana Mana some statutory protections. Okay. This is the thing. Now, what are the legislative provisions, or let's study this Prevention of National Insults to National Honor Act in detail. Okay. Now, let's talk about the existing provisions and then post-amendment what will happen. Alright. So, Section 3 penalizes insults or disruption to national anthem only. And only word is important, only national anthem. Whenever national anthem is playing, you cannot disrupt it. But when this provision will be amended, this Section 3 shall also penalize national song disruptions. So if you disrupt national anthem currently, well, you are penalized. Now that will apply to Vande Mataram as well. Then intentionally preventing the singing of national anthem or causing disturbance to an assembly which is singing national anthem. If you're disrupting that assembly, well, that is also a criminal act. Okay. Now this provision shall also apply to national song. And punishment, imprisonment up to 3 years or fine or both, this will extend to national song as well. Okay. Plus there are many other provisions, many other rules, code of behavior, everything is written in this law. We are not going to get into that. The point of this discussion is that national song shall be treated at par with national anthem, which was not the case, though it was, well, promised by the first president of India, Dr. Rajendra Prasad, in the Constituent Assembly. He made that promise, or not promise, he made that assertion. But legally speaking, as per this law, only national anthem was given that protection. Now, to understand why this was done, you need to understand the history of national song. Okay. So let's talk about historical foundations. So this national song, Vande Mataram, was composed by Bankim Chandra Chatterjee, okay, in 1875 in his novel Anand Mat. Now, this song, Vande Mataram, became a rallying cry during the Swadeshi movement, freedom movement. All freedom fighters used to sing Vande Mataram. It is a very famous song. But the thing is that, well, it is a long song. Some stanzas, well, some end stanzas or some stanzas after stanza 2, well, they have a communal tinge also because you are using a lot of Hindu symbols in that song. Okay, that is why Congress decided to keep only the first 2 stanzas of this song, because they thought that India will be a secular country and other religions might object to the other stanzas that we are omitting. So the national song portion is only the first 2 stanzas of this original song. Nonetheless, this song was extremely important during the freedom struggle. Okay. In 1937, Congress Working Committee's resolution. The Congress Working Committee in 1937 adopted first 2 stanzas of Vande Mataram as the official national song to ensure inclusivity. Like I said, stanza 3, stanza 4, well, they are, to put it mildly, a lot of Hindu symbols are used in that. So other religions might object to it, hence, for that reason. Now, Dr. Rajendra Prasad declared the song Vande Mataram, which has played a historic role in India's freedom struggle, shall be honored equally with Jana Gana Mana and shall have equal status with it. He made this assertion, but the law passed by the government did not make that assertion or allow this assertion to come to reality. National anthem was legally protected, whereas national song was culturally protected. While the Constituent Assembly granted equal honor and status to national song, the original 1971 Act consciously restricted statutory criminal protection under penal law to national anthem alone. Okay, now, this is the issue. Now with this amendment bill, national song will also be treated at par with national anthem. And mind you, currently the national song is only the first 2 stanzas of this long song composed by Bankim Chandra Chatterjee. Okay. Now, what are the constitutional debates regarding this law only, Prevention of Insults to National Honor Act? Okay, freedom of speech and expression. You see, many people object to the fact that when national anthem is playing, some people are not standing or not singing it along. This is insult to national honor. Well, Supreme Court has opined on it. Okay, Supreme Court has given their opinion on it. So Supreme Court held that Jehovah's Witnesses, Christians, students who stood respectfully during national anthem but did not sing it due to religious beliefs were protected under freedom of speech and expression and freedom of religion. Basically, the Supreme Court said that they showed respect, but they did not sing because they thought that singing that would violate their religious feelings or religious beliefs. Okay, it can happen. You have freedom of religion in India. Now, still, if you'll force them to sing that song or sing national anthem, well, then critics argue that criminalizing non-participation risks transforming a symbol of voluntary patriotism into an instrument of legal compulsion. People should respect it voluntarily rather than you make it compulsory for them. They are respecting it. Don't force them to sing. Okay, this is a huge controversy. Clear? Plus, well, judicial observations on Vande Mataram have been here. The Supreme Court previously observed that executive advisories directing singing Vande Mataram at official functions were purely advisory in nature, carrying no penal threat. The 2026 bill creates statutory penal consequences. Yes. Earlier, There was no law protecting national song, but the government used to pass notifications saying that in these official functions, Vande Mataram would be played and you have to respect it. Someone challenged it, that there is no law protecting Vande Mataram, so how can you force us through an executive notification? So the Supreme Court said that this is a voluntary notification. I mean, it's not compulsory for people, but now it will be, okay, if this amendment bill gets passed. Okay, now there is this huge debate with respect to respecting national symbols, national song, national anthem, and forcing people to show respect outwardly. You can respect it in your heart, but not show it out like explicitly. Okay, now there is this debate. Should we make it compulsory for people to explicitly show respect? So there is this continuous tug of war between nationalists and people who project or people who promote liberal school of thought. Okay, now what is the way forward? How to marry these two so that there is national cohesion? People are all together in this. Okay, harmonizing respect with liberty, balancing national honor with fundamental freedoms require clear distinction between active disruption. I mean, you have to clearly mention what disrespect means. You have to clearly write it down so that you cannot harass people when they are not disrespecting national anthem, yet you accuse them of doing so. Okay, constitutional tolerance. Our tradition teaches tolerance, our philosophy preaches tolerance, our constitution practices tolerance. Statutory protection should enhance national cohesion rather than forcing people. So these are some of the points that you can write in your mains answers as conclusion. These are good. This is good language. Okay, so use it, right? And now let's come to next topic, which is relevant, highly relevant in the current context, and that is, are protests legal in India? Of course, protests are legal in India. Our constitution allows us to protest. But now if we talk about this right to protest, it is legal in India to protest. You have the right to protest, but there can be reasonable restrictions applied to you by the state. This right to protest is heavily regulated. There is a legal architecture around it. There are laws. You can protest, but there are rules and regulations within which you have to protest. Okay? Right to protest is constitutionally protected as well. But again, there are reasonable restrictions. So what is the scope of right to protest? What are these reasonable restrictions? What is the entire paraphernalia, legal paraphernalia with respect to rights of students, or let's not say students, Indian citizens right to protest? Let's talk about this issue. Okay, you need to be aware of this. So are protests legal in India? Okay, recent clashes during Sansad Chalo, well, you all know about the current context. Okay, let's talk about the constitutional foundations of this right to protest. Okay, so Article 19 is the constitutional foundation. So Article 19, Clause 1, Subclause A gives you freedom of speech and expression. Subclause B gives you the right to assemble peacefully without arms. Again, that means that protest is allowed, but only peaceful protest is allowed. Of course, we all know about this. Okay. And subclause C, right to form associations or unions, NGOs, and all of that. Clear? So our constitution, somehow, these three articles or these three clauses within Article 19, well, they allow right to peaceful protest. But it's not just the constitutional protection. Well, protesting is part of our political culture, and that political culture got developed during our freedom struggle. We use this right to protest to basically throw British rule away from India. That was the entire culture. Protesting was the entire culture of our freedom movement. And yes, if we talk about Congress's evolution, Congress was at the pinnacle of freedom movement. Okay, they were at the forefront of freedom movement. Well, they always promoted peaceful protest because of Gandhiji's leadership, right? So peaceful protest is part of our political culture also. It's not just constitutionally protected. In fact, India reiterated this at United Nations Human Rights Council. You should know this. India highlighted that non-violent, organized public marches were primary weapon during the Indian freedom struggle. Hence, it is part of our political DNA. Okay, it is part of our political DNA, embedding the right to peaceful assembly into foundational ethos of Indian democracy. So right to protest is not a legal right, it's a constitutional right in a sense, but it's very, more importantly, it's part of your political culture, your political ethos, like I said, political DNA. Whenever you're unhappy with the government, you have the right to peaceful protest, or you always go for peaceful protest. This has been part of India's history even after independence. Okay. Now, the thing is, let's go to the constitution. Let's go back to constitution. Okay. Let's not come to political culture. Everyone knows about it, that it's part of our political culture. But let's go back to constitution. Okay. Now, these three sub clauses of Article 19 do grant you right to protest. But again, right to protest has reasonable restrictions on it. And why are there reasonable restrictions? Well, simply put, your right to protest cannot disrupt someone's right to life, right to liberty. You will block a road. Suppose that person goes to work through that road every day. You'll block his passage. You'll block his right to livelihood, right? So public order, security of India, integrity of India, these need to be balanced with your right to protest. This is important because your right cannot encroach upon someone else's right to life. You understand, right? So we have to apply reasonable restrictions. Now, these reasonable restrictions are mentioned in Article 19, Clause 2 and Clause 3. What are these reasonable restrictions? You should be aware of them. Number one, sovereignty and integrity of India, security of India. Okay, this is paramount. No peaceful protest can disrupt this. If there is a peaceful protest because of which India's friendly relations with foreign states are being harmed, suppose there is a foreign dignitary, a prime minister of a friendly country coming to India, and you block his passage by protesting, this is not allowed. Okay, public order, decency, morality. Okay, this is there. Contempt of court, you cannot go for contempt of court. Defamation or incitement to an offense. Now, these things are written in Article Clause 2, Clause 3, right? These are reasonable restrictions. Now, who will decide whether police action is there to enforce reasonable restriction or not? Well, the courts decide that. So whatever police action is being taken or has been taken in the past on protesters, that needs to be checked by the courts, and the courts run a test of proportionality. Whether police action was proportional with, well, proportional with their aim. So if the police are saying that we want to establish public order, now that can be established by normally asking protesters to move to a particular side, or gently nudging them, or not gently nudging them, forcefully also nudging them. But if you start showering them with pellet guns, that is disproportionate reaction. So this proportionality test is checked by the courts of India, whether police action to impose reasonable restrictions are proportional action or not. The reaction of the police should be proportional to the action of protesters. You understand the point, right? Now, the regulatory framework. Now we have established that you have right to protest. It is there. But again, it is heavily restricted and there are proper rules for protesting. The state ensures that. Now, what are those rules? To balance individual rights with public convenience, state administration regulates assemblies using statutory tools. So, you want to protest, you have to give it in writing to the government, and a designated protest site is given to you. Administrations assign specific locations for public demonstrations to avoid governance and traffic. Yes. Mandatory police permission. Prior notification permission allows authorities to deploy adequate security and manage traffic routing. So you have to take police permission for protesting. Prohibitory orders. Section 163 of Bharatiya Nagarik Suraksha Sanhita, which was section 144 of CRPC, but it has been replaced by BNSS, empowers magistrate to issue orders preventing unlawful assembly or public disturbance. Okay, so the magistrate can issue orders to block gathering of people. He can say that now public order has been significantly disrupted. Now an assembly of more than 4 people, which is a curfew, okay, assembly of more than 4 people is not allowed. This power is given to the magistrate. So these are the legal things, rules that you have to follow for a successful protest. Clear? Make sense? Now, yes, there are a few judgments given by Supreme Court also, like Himmat Lal Ke Shah case, upheld the fundamental right to public assembly face-to-face, holding that while, this is important, that state can regulate public places to ensure safety, regulation cannot amount to total prohibition. Okay, you have right to protest, but state can regulate it. Then again, in Mazdoor Kisan Shakti Sangathan case, the the Supreme Court reaffirmed Jantar Mantar as designated protest space, ruling that complete bans on protest in central Delhi are unconstitutional. Basically, government came out with a notification that in central Delhi, Jantar Mantar, you cannot protest. So the Supreme Court said, no, you need to designate a specific site for protest. Then Amit Sahni case held that public ways and roads cannot be occupied indefinitely. So you can protest, but you cannot cause indefinite public inconvenience, which happened in the farm protest. So this is there. Clear? So basically, the authorities and the protesters have to do this constant juggling, constant balancing. You have a constitutional right to peaceful dissent, accountability from state, non-violent public assembly protest. But public order is also important, and it is a responsibility of the state. So state has to ensure that these protesters do not harm the fundamental rights of others. Free movement of citizens, disruption to traffic, avoidance of law and order breakdown. Okay, stampede-like situation, because if there is a stampede at a protest site, people would blame state only. So the state has to take care of this also. So there is this constant tug of war between this. Right? That's about it. Now let's quickly shift our focus to next news item, and that is two-child rule for Panchayat elections. Basically, 1994, Haryana passed a law in which all the people fighting elections for panchayats, well, they would be disqualified if they have more than 2 children. Okay, so they came up with a two-child rule. The attempt was simple: to disincentivize people having more children to control the population of the state. Now, it was not just Haryana. Many other states of India, including Maharashtra, they also started enacting these laws preventing people having more than 2 children to contest elections. Now, this law was challenged in the Supreme Court, and basically in 2003, Supreme Court validated this law. Supreme Court basically took the side of the state. Okay, but now recently the Supreme Court has decided to review its previous order in which it allowed the state to make this two-child rule. Okay, now the courts are thinking that we need to review this judgment. Okay, because people are making valid arguments that, well, this two-child rule is violating some people's fundamental rights, okay, or bodily autonomy and many other things. So what is this entire issue? Let's talk about this, okay? So two-child rule for panchayat elections. So what is the current context? So a disqualification order was passed under section 14 of Maharashtra Village Panchayat Act against a sitting sarpanch. The allegation was that that sitting sarpanch had a third child. Now the order was passed. The sarpanch actually challenged that order, saying that, well, they did not have that child, and the courts, the government did not allow them due opportunity to cross-examine documentary evidence, birth certificate and all. Basically, they were saying that this child is not there. That was the case, basically. And the government did not allow them to give their side of the story. So that order went to the courts. Considering similar disqualification clauses in multiple states, the SC appointed amicus curiae. You know what amicus curiae is? An expert appointed by the court to study a particular matter, to review the status quo of two-child qualification nationwide and examine their contemporary relevance. So because this sarpanch went to the Supreme Court thought that let's not just address the issue of this sarpanch alone. Let's address the entire issue. Okay, let's take a look at the legality and constitutionality of this two-child rule. Okay, now this is the background, current background. Now, as far as the previous stance of Indian judiciary is concerned, here's the thing. The 3-judge bench led by Justice R.S. Lahoti upheld section 175 of Haryana Panchayati Raj Act. Okay, so people challenged this law made by Haryana, okay, in which two-child rule was mentioned. Supreme Court's 3-judge bench upheld this law, and their arguments were, first of all, right to contest election is not a fundamental right. Okay, it is a statutory right, which means it is a legal right, which means this right is provided by a law made by the legislature. So if this right is because of a law made by legislature, well, the legislature can make another law to restrict this right. Okay, therefore the state legislatures have full competency to lay down qualifications and disqualification because this right came from their law only. So they can add any qualification, disqualification they want. The courts cannot interfere. Plus, as per Article 14, the state cannot discriminate against anyone. Many people said that you are discriminating against people having more children. Now, under Article 14, there is this concept called, well, right, equality before law and equal protection of law. Under equal protection of laws, well, the state can discriminate, but if there is a valid reason for it. Okay, they call it intelligible differentia rational nexus. The court said that Haryana's law passes that reasonableness, intelligible differentia, rational nexus, so it is allowed. Following Haryana, Maharashtra, Odisha, Andhra Pradesh, Madhya Pradesh, Rajasthan came out with their own two-child rules. Now, the Supreme Court is thinking about reviewing this judgment given by Justice R.C. Lahoti. Now, why are they doing so? Well, there are certain arguments against this two-child rule. Okay, critique of two-child rule. First of all, demographic realities. The rule was brought in to control population, to make people have less children. But now India's total fertility rate is declining. People need to have more children if you want to protect India demographically. Now, the relevance of this rule is no longer there. Plus, when you ask people to have fewer children, well, patriarchy creeps in. It promotes sex selection, female feticide, abortions, all of this, because people want to have more male children. And if you're forcing them to have less children, well, they would want to choose males only in that. So this is a problem. Because people, there is still this mindset that we don't want two daughters. Okay. Then grassroots democracy. If you are applying this rule, then apply this rule to MLAs, MPs also. Why are you applying this rule only to Panchayat, local institutions of local self-governance? Okay, that means you are not that honest about promoting grassroots democracy. So this is the thing, right? Now, the courts will look at this matter afresh. Let's see what the what the Supreme Court justices or the Supreme Court judges decide. The matter is there to unfold in future, but what can be done? What is the way forward? You need to be aware of this. So yes, we need to re-examine this judgment. We need to have proper population control policies, not banning people if they have more children or penalizing them, and harmonize grassroots leadership, basically promote grassroots leadership. That's about it. Okay. And now let's quickly shift our focus to next news item, and that is, can courts stop CBFC certified films? Now, let me give you a background. This is a very important issue which involves Article 19, Clause 1, Subclause A, freedom of speech and expression. You see, people have the right to make films, and that is protected under your right to free speech and expression. Okay, but the state can apply reasonable restrictions. Okay, now for those reasonable restrictions, the government has enacted a law called Cinematographers Act. Under Cinematographers Act, there is this body called Central Board of Film Certification. Your film needs to be certified, then only it can be played in theaters. Okay. Now, this CBFC body is responsible for giving you different categories of certificates. Okay. A certificate, adult certificate, UA certificate, all these certifications are given. Once the certification is given, after proper review, okay, then your film can play in theaters, right? Now, recently in Odisha, a film was made related to Lord Jagannath. Okay. Now, some people allege from Odisha that this is hurting the sentiments of Odisha people who idolize Lord Jagannath. For them, he's the Lord is everything, right? So they are misrepresenting the facts with respect to Lord Jagannath. So they seek the ban in Odisha High Court. Odisha High Court issued a ban. And not just a ban in Odisha. Odisha High Court issued a ban in the entire country. Okay. Now the filmmakers went to Supreme Court, and the Supreme Court basically lifted that ban. Okay. Supreme Court said that, look, the nationwide ban is not tenable. We won't allow it. And as far as the as far as Odisha ban is concerned, well, we won't ban this movie in Odisha also, but we would postpone its release after the Yatra, the Puri Yatra for Lord Jagannath. Then the film can release so that religious sentiments are not hurt. Okay, this was done by Supreme Court. But this raises a debate whether a legal body like CBFC, whether they have any powers or not. Basically, a statutory body gave a certificate, gave a go-ahead, and then courts blocked it. This is problematic, and there are so many issues in it. So let's talk about it, okay? So this is the context. I explained it to you. Now the issues, the legal constitutional issues are Article 19, freedom of speech and expression, free expression, CBFC authority. It is a legal authority. Once they give certification after due scrutiny, how can court stop it? Okay. And basically, the Supreme Court has talked about this concept. This concept is important for you to understand. Heckler's veto. If 3 or 4 people shout at the top of their lungs that this film hurts their sentiments, and if you don't stop this film, we will create law and order problems. You cannot cancel a film based on a threat. You have to look at that film holistically. Okay? This is Heckler's veto. That 3 or 4 people can stop a movie's release just because they have the capacity to create law and order issues. This is a big problem. So this is being debated, and the Supreme Court took the side of filmmakers in a sense. Now, this is Cinematographers Act. So a few sections of this law, it is important for you to know, okay? And Article 19, well, we all know about it, reasonable restrictions and all. Okay, that's about it. And there is a way forward also suggested in your notes, so do go through that. That how can you further prevent such a situation? Because you see, last minute ban is really bad for filmmakers. Filmmakers have spent so much money on it. Okay, all their time, money, energy, resources gets cancelled when, well, someone applies Heckler's veto. So these last minute bans shouldn't be allowed. Okay, and the Supreme Court has taken cognizance of this because money is involved. People's hard work is involved, right? So if you want to ban a film, ban it beforehand. Make sense? So there is some way forward suggested. Do take a look at it from the notes provided by us. It's very easy to understand. All right. And that would be all. With that, we conclude today's session. So thank you so much for watching, everyone. And I'm sure it has added value to your preparation. I'm sure about it. Now, please do not forget to revise this lecture from the notes provided by us. Otherwise, you'll quickly forget these points, okay? These current affairs. So make sure you spare another 15 minutes revising these current affairs. All right. On that note, I shall take your leave with the promise of seeing you again with another set of news items. Thank you, everyone.